Good morning, good afternoon, good evening, honorable judges, esteemed speakers, partners, colleagues, students, dear participants. A warm welcome to the inaugural roundtable of the Talking Courts project. Courts talk a lot. One of the best known associations with courts, at least in the Western context, is that they are the mouths of the law, as Baron de Montesquieu put it. They issue decisions with extensive justifications. In addition, many courts have recently begun to use other forms of communication, such as press releases or even social media, to explain their decisions and reasoning and connect to the public. Despite these efforts, however, courts often remain seen as isolated from the broader public, with judges sitting in ivory towers remote from broader attention. Talking Courts is therefore a new educational and awareness-raising project that aim to humanize courts and judges and bring them closer to the public through various event formats, as well as development of a university-wide course syllabus and judiciaries in democracies. My name is Max Stoyer. I'm the project coordinator of Talking Courts and an academic based in Slovakia and in India. I have a pleasure to introduce some of the partners of this initiative. Talking Courts is hosted by the Department of Political Science of the Communist University in Slovakia. I have the pleasure there to collaborate with the head of department, Associate Professor Erik Láštic, and Pavel Žilinčík, former member of the Judicial Council on Slovakia. And there is a significance in Slovakia being the host jurisdiction because the judiciaries play a pivotal role in safeguarding and entrenching democratic foundations, particularly in transitional regimes such as Slovakia. And we will hope that through the activities of the Talking Courts project, we will contribute to this aim. It is not a coincidence that we are meeting during the Human Rights Defenders Day, as I was told the day before the Human Rights Day tomorrow, because there is a strong element in human rights education entailed in this project. And we have some of the best partners for that. The Human Rights Olympics in Slovakia, led by Dr. Dagmar Horna and her team. We have the Helsinki Committee for Human Rights in Slovakia, led by Dr. Silvia Tiriaki. And we also collaborate with the UNESCO Chair for Human Rights Education at Communist University. I would also like to express my sincere thanks, besides them, to the Seeley Institute, particularly to Dr. Freda Greeley, who provided invaluable support to reaching out with to court insiders in several jurisdictions. I would like to thank my colleagues at the Jindal Global Law School, including Suprita Acharya and Aditya Verma, for their support, and we hope to generate in this project a transfer of experiences and insights beyond the Western jurisdictions. Last but not least, the project would not have been possible without the US Embassy in Bratislava, who provides the funding for Talking Courts via their small grants program. And I would like to welcome Ms. Gabriela Shaturova, political specialist at the embassy, and give her the floor to share a few words. Thank you.
Thank you very much. So hello and welcome on behalf of the US Embassy. We're very happy to support this project because we believe that an open discussion on courts and on the judiciary is vital to bring this topic to a wider public, and we see that it's very much needed. I would also like to express our thanks to the distinguished panelists, guests, including US judges who are joining us very early in the morning, so thank you for that. And I wish you a fruitful discussion. Thank you very much, Mr. Stoyer and the organizers for providing this platform and hosting this transnational exchange.
Thank you very much for those kind words. And of course, as you said, today's event would not have been possible without our esteemed speakers. We are honored and grateful for them to find the time for what is an even busier schedule than that of the academics. We are convening today virtually to discuss on courts and COVID-19 because we felt that the role of courts has received little attention, especially through engaging with concrete experiences and perspectives of the court insiders. There are central issues of protecting human rights, democracy, and the rule of law entailed in this discussion. And instead of me speaking for more, it is just my privilege to introduce Dr. Joel Grogan, who has been contributing to this area of knowledge of research very significantly. She's a senior researcher and leads the research team at UK in a Changing Europe, also a research fellow at the CU Democracy Institute, the co-director of the Good Lobby Profs, and among others, the editor of the Routledge Handbook of Law and the COVID-19 pandemic. So we could not wish for a better navigator through today's discussion. Now, before I hand the floor over to her, we hope this to be an interactive session, which is why we are recording it. Please, if you don't wish your camera to be recorded, turn it off. Dr. Grogan will start with a few questions, but our attendees are most welcome to formulate their own questions and comments. There is the Q&A function for this purpose, and at a later point, if the technical conditions allow, we will also invite comments on the floor and hope to address as many questions as possible. Thank you very much, and Joel, over to you.
Many thousand thanks to Max, and also congratulations to my end, to him and all of the organizers on what promises to be a fantastic series and a very, very important contribution to the conversation of courts and their role not only within the legal system and in the pursuit of justice, but also very, very importantly, just in our societies. And I think that's something that we really can reflect on now, coming up to nearly 4 years since the declaration of a pandemic in 2020. So, as Max said, it is my joy and privilege to be chairing this esteemed panel of speakers from throughout the world, joining us in very, very different time zones. And I say a little jealously, probably with better weather than I'm having here in London. But with that in mind, I'm going to be doing a veritable tour of the world, starting first with Slovakian representatives. So speakers from Slovakia telling us about their experience within the pandemic and the courts. What I'm going to do is first invite everyone to give their initial reflections on how pandemic affected the courts. So pandemic affecting the way in which we see courts running and their own experience within it. So before we look to lessons or insights, just an initial framing of the experience of pandemic. With that in mind, I'd like to first turn to Dr. Jan Stavinsky, who is a senior advisor of the Constitutional Court of the Slovak Republic. So first, over to you. I would ask if they could also unmute themselves.
Sorry, now it's okay.
Yes,
hi.
Please go ahead.
Thank you for the word. Thank you, Max and all organizers for hard job to organize such event. It's a nice community, 2 giant democracies and 1 less populated democracy. And my impressions from reacting of course to COVID, speaking not only in Slovakia but generally, is that law is per se a very conservative tool. So law reacts to past events which we know, which we are adapted to. And COVID was a very different situation, that something very new occurred, and it was more place for executive and other branches to react, and this is the reason why, in very neutral way, saying that it was not finest hour for the court. Courts should react very carefully and not to do some policy stuff. So this was a special very special situation for the Kurds, that they have to react to very new situation, very new circumstances. So this is my first point, and my second point is that the state, the power, was in double-sided position. That in one way, state have to protect health. State have to do some positive measures to protect health, and on the other side, state have to respect limited power, have to respect human rights. So it was not easy for the state to be in those both roles, and for the Kurds to watch the state in those two roles. So this is second point which I want to stress. And one more local remark to Slovak situation. Recently, I sometimes opinion in public and also among legal scholars was that Slovak judiciary react less active than Czech one in comparison. And recently I've heard document issued by Czech Parliament, which all Czech decisions were analyzed in a very complex way. And if I compare Czech situation and Slovak, as far as protection of human rights, the Czech protection was not much more intensive, in the sense that if the Kurds interfere in measures issued by government or by parliament, but usually by executive, the typical reaction was that executive have had to give more in-depth reasons to their measures. So it was more procedural stuff than, let's say, substantive stuff. So this was for me kind of confirmation that it was very expert stuff, COVID situation, and Kurds could stop just very intensive interference to human rights. And in this sense, in Slovakia, I think Kurds did that comparing Czech and Slovak Republic practically, as from point of view of citizens, the interference from the executive was very similar. I had the problem more with the maybe symbolic stuff, that the feeling of citizens could be that judiciary is more passive here, but the reason is has also some procedural issues, because access to individual protection against general norms and general measures is more complicated here in Slovakia than in Czech Republic. But this would be like first introduction, and then I can explain particular decisions of Slovak Constitutional Court and Slovak judiciary, and how Slovak Constitutional Court protected human rights, and how it develops its how it has developed its case law. So thank you for your attention.
I'd like to keenly thank Dr. Sjavinski for laying out so many of the core issues that, as we can tell, not only were so important in terms of thinking about judicial practice in Slovakia, but how we could easily talk about it in every court throughout the world. The question of rights, of rule of law, of access to the courts, but also the very difficult circumstances of pandemic. I'm very aware that we're all quite familiar now with Zoom and Teams and all of the other different applications. But as we've just heard, the challenge of the role of judges within that space, within pandemic, is not clear. So I'm very keen to talk more about rights and, as we've heard, the decisions that came down from the courts. But first, again, thinking about the initial response or initial reactions, I'd like to stay in Slovakia for a little bit longer and turn to Judge Martin Wernarski, the judge of the Constitutional Court of the Slovak Republic. Again, exactly who we should be turning to in such important questions. So,
when perhaps dealing with the measures that dealt with the pandemic, I would like to perhaps complete what he said about my authentic experience from this period. First of all, I would like to highlight that I think that the society as such was not prepared for such a challenge. By that, I don't want to say that the legal system wouldn't have the necessary tools for that to deal with these issues of perhaps some emergency situations which include the pandemic as well. But what I feel is that in the past, perhaps in the distant past, when these instruments and institutes were implemented, nobody could fathom that they will be tested in such a significant way sometime in the future. So this is perhaps the first note on my feelings or reflections. The second point, I would like to confirm what Dr. Sjavinski said, and that is a certain room for maneuvering of a judge who has to understand two limits. On the one hand, that's a flexible reaction in these situations, that this space really has to be respected and supported as well. But on the other hand, the fact of the respect to the executive has to make courts which test or examine the acts of the executive to be perhaps more cautious and more strict as well, as was said in one of the decisions of the Constitutional Court, to be a bit more suspicious towards the executive. So this may be perhaps another note and another reflection from my side. The third point which I want to mention is that I want to reflect on what has already been mentioned in the introductory remarks, and that is that courts are sometimes seen by the public as something in the ivory towers, that they are distant from the society. They only deal with legal institutions, legal forms. And from my personal experience, but just for me personally, I can say that this is not the case for me. I myself have noticed that as a judge, I was also thinking about the problems in a human way that were created in connection to the pandemic. And the human factor is needed for a correct thinking about the cases. I want to believe that this was a good foundation to make sure that the decisions that I made were authentic in the specific cases and that I had the best intentions in them. Whether the decision is completely correct, substantively perhaps, whether it has no flaws, no errors, whether we can find some gaps in it, perhaps, or some weaknesses, well, that's a different question, and that's a question for the evaluation in the future from the side of the academia, for instance, also from the side of the public. So this is basically my third note, third comment. And perhaps lastly, I want to return to the first one when I mentioned that the pandemic of COVID, well, we were unprepared for that. And very often in the public discourse, in the discussions, the starting point and the constant is the view of the public, the opinion of the public, criticism from the public, perhaps the lack of understanding for some measures, also criticism to the public authorities that they weren't able to describe and explain the measures to the public. The public didn't understand them, and that's why they weren't prepared to respect them strictly, because they didn't see any logic in it. And by what I'm saying, I want to say that we really have a strong feeling that the starting point of the public and its opinion is the evaluation criterion based on which we have to talk about the correctness or falseness of any measure which has been adopted by the executive, or also decisions by courts, which then perhaps examined these executive measures. But if we are speaking about the fact that the whole society wasn't prepared for this pandemic, well, there's a question whether the expectations of the public are not a manifestation of this lack of preparedness. This is also a question of whether the members of the public communicated among themselves about these measures, about the findings of courts which examined these measures. So I don't want to shed doubts on everything and to give some stable starting point to our discussions, because I think that we have something like that, and that is the fundamental rights and freedoms in the viewpoint of an effective protection for human rights. And I think that in such an emergency or unique situation as the pandemic was, we have to understand that we cannot think that each individual understood the extent of how they can implement or exercise their own basic rights, whether they viewed them in relation to the rights and freedoms of the other ones, because this is the public interest on the protection of the public health. We are always we have always problems with measures when some basic rights are restricted. But the public interest in the case of the pandemic and the epidemiological measures has some kind of a special connotation, a special smell, so to speak, because it's a collection of individual interests of the individuals on their protection of their health. So I think that as people that know the area of the constitutional and human rights understanding of an individual's position in the society, we have to be a bit more reserved in our viewpoints of the question whether the opinions of the public, which are formed, for example, on social media and other platforms of public debate, whether these opinions should be a starting point for the evaluations of any measures that the state is adopting when trying to protect health against the pandemic, and then also in relation to the judicial decisions which were the result of examining such measures. So that's it from my side for the beginning, and in further discussion I will gladly speak about that.
Many thousand thanks. Again, that was fascinating, and I can keep echoing that here with say about what's happened worldwide. In fact, I just want to echo again 2 points that I think we'll be picking up on a lot throughout the course of the discussion. First, and perhaps most importantly, the human element, that often when we think about law, we can think about it in a very abstract way of what we should do, or what law says, or what legislation is. But the reality of the pandemic showed us the importance of law and the importance of the public understanding law and understanding the reason for law. And within that context, the importance of courts in ensuring that the law was right, that rights could be understood, that rights were accounted for, but also ultimately the human elements and the rule of law. Again, important themes that we will pick up on. Again, thank you so much for that initial opening remarks. We're going to stay in Europe for a little while longer as we turn now to Croatia. And Judge Ksenia Flak-Makitan, forgive me for my terrible pronunciation of names, by the way, always correct me. But she's a judge at the Commercial Court of Varaždin in Croatia. Her experience of the court's pandemic.
Thank you so much for letting me speak at your panel. And I would like to say that Croatian Civil Procedure Act, even before the pandemic started in 2019, had provisions that allowed courts to have remote hearings using video conferencing platforms. So when pandemic occurred, judges were strongly encouraged from the President of Supreme Court of Croatia to start with remote hearings. So based on the enthusiasm of judges, availability of IT staff, internet and video conferencing platforms, we developed during these 2 years of pandemic extensive and good practices. I must say each court developed those good practices for himself. So during the pandemic, I had the opportunity to be a part of online remote judging workshop organized by Sealy Institute in Prague. That lasted for several months, and it helped me to the knowledge. It helped my knowledge in remote hearings to be more efficiently used in my courtroom each day. So after this workshop was finished, a smaller group of judges that participated in that workshop was starting to write practical guidance for remote judging. And now I will just briefly show you in 2 or 3 slides what it looks like and what is it about those practical guidelines. So I will just start to share my screen now. I'm not sure. Okay, do you see that? Hello.
Not yet.
Not yet. Okay, that means that I often have some kind of problems when sharing the screen via Teams. You know, one of the things that we had a problem during the remote hearings, it is the internet connection. So I'm going to try again. It should work. Yes. Share. Nothing. Well, okay, now has something changed?
Afraid still not yet here.
Not yet. Okay. Well.
Sorry, Judge, excuse me. Maybe I can try to share your slides from my end.
Yes. Okay.
So I'm just trying to share. Can you see it now?
Yeah, working now.
It's working now. Okay, great.
Yes, so it's from my screen. So please just tell me when you would prefer to switch slides.
Okay, as you can see here, there is a cover of the practical guidelines for remote judging. As I said before, it was a teamwork that engaged several judges from several countries. And I must mention that there would be no guidelines without a tremendous work that was done from Rachel Murray, professor from University in Bristol, and Frida Greeley from Sealy Institute. Those two persons coordinated and helped with the creation of this publication. So you can turn the slide to like this. Do you see the next slide?
Yes.
Yes.
Okay. Well, as you can see, remote judging guidelines are practitioners' reading. They are easy to comprehend and can be used not only by judges, but also by other practitioners. They cover diversity of topics, contain glossary, and each chapter has a checklist for better application. It is printed in practical format and it has 63 pages. Some of the things that these guidelines are dealing with are opportunities and challenges in remote judging, international standards of justice that must be upheld, determining whether a matter is suitable for remote judging. There are important things about technologies and case management and practical tips for each phase of the procedure, such as principles of conduct, communication between client and lawyer, witness testimonies, public access, data security, etc. And now we can go to the next slide. I made a comparison between Sealy guidelines and CEPE guidelines on video conferencing in judicial proceedings that were published in June 2021. So if you can see that Sealy guidelines are quite in the track with that CEPE guidelines, but the guidelines are more practical and it is just made for practitioners' use. And the last slide that I'm going to use is some statistics that Sealy made in 2021. They interviewed 70 judges from 19 countries from diverse levels of courts. And you can see here that the judges thought the legislation was a barrier for remote hearings, yes, in 64%, because there were some countries in Central and Eastern Europe, they didn't have any kind of legislative background or that would allow them to use remote hearings. Also, do the courts have a stable internet connection? Yes, 54%, but 44% said sometimes or often have problems with internet connection. And that is the case also with me in Croatia. I don't have to postpone my hearings too often, but sometimes I cannot have them because of the bad connection. The last statistics I'm going to show you is that when hearing a witness or an expert in the civil procedure, 54% of judges are going to do that in the courtroom before the judge. My experience with that is to have my lawyers or parties in the procedure online, and witness or expert is coming to the court, and I will place him in a separate secure room and environment. So that is how I do it, and most of my colleagues follow that kind of procedure. So I'm going to stop sharing the screen, and if you have any kind of question about Sealy guidelines or some specifics in how did we do it in Croatia, you just go ahead and ask. Thank you so much.
Many thousand thanks to the judge. I think, again, I will highlight one of the very important aspects that we found, again, globally during pandemic, which was how quickly or how able legal systems were to go to remote hearings and remote viewings. And in that, it actually, as has already been introduced by the judge, exposed one of the biggest issues in pandemic, which was internet access, and how that is such a dividing line between people and communities, and even just how to navigate the challenges of the legal system and internet. But we are wildly going to jump very, very far across the globe to join our very early speakers in the United States. And we're going to begin with Judge David Campbell, who is a senior judge at the U.S. District Court for the District of Arizona in the U.S. I dare not ask you how early in the morning it is for you, but I do hope you've had lots of coffee before you tell us about pandemic in the U.S.
Well, thank you. It is early. I've got a good cup of water, so I'm doing fine. I am a federal district court judge in the United States, and as some of you may know, the federal courts in this country are a nationwide set of courts that deal with federal issues, but we have judges in individual states, and so I'm based in Arizona, but I'm in a federal court sitting on federal matters. It's all coordinated nationally. We also have 50 different sets of state courts, and we have with us Justice Cooper, who's my counterpart in the great state of New York in the state courts, and so in one sense, in dealing with the pandemic, we had 51 laboratories within which to experiment, the federal system and 50 state systems. And many of the states were the leaders in helping innovate in this area. But I'll describe what happened in the federal courts briefly. We had the same challenges I think everybody else did. One of the initial challenges was that we, within a matter of weeks, had to shift from a workforce of 20,000 people who would come into courthouses and do their work every day to all of them working remotely. And so within about a month, we shifted to 100%, almost 100% remote employees within the federal court system, 20,000 remote connections daily through our virtual private network. And fortunately, the technology we had in place and the technical experts allowed that to work quite well. And so I, along with my staff, began working from our homes and connecting to the courts remotely. We also had the question of court docketing and court papers and court filing. Fortunately, in the federal courts about 15 years ago, we had shifted over completely to an electronic filing system so that parties were able to file documents electronically from lawyers' offices if they were representing parties, or in the case of self-represented individuals and they had the technology, they could do their filings electronically. They could check docket entries. They could look at case status electronically, and that proved very helpful when we suddenly went to a virtual court system. Our greatest concern as judges was the fact that our cases were going to come to a halt unless we could find a way to manage them virtually. As was said by the judge from Croatia, our civil case management system, our civil rules were flexible enough that judges on their own could shift to remote hearings. And so I immediately shifted all of my hearings in civil cases to either video or teleconference hearings. And that worked pretty well. I even held a virtual trial in a civil case during the pandemic that worked pretty well. It was a bench trial, meaning I was the decision maker. The bigger challenge we faced was in our criminal docket. And it was particularly a problem not only because we all care about people who were incarcerated and waiting for their trial date, but we also have a Speedy Trial Act in the United States that requires that a criminal trial be held within 70 days of the date on which the defendant is charged. And if we could not hold criminal proceedings, we couldn't process those cases within the speedy trial deadlines we were facing. And yet our criminal rules were largely designed for in-person hearings. In fact, under our Constitution, criminal defendants, people charged with a crime, have a right to be in court personally, to attend all of their proceedings, to confront the witnesses who testify against them, to have a lawyer sitting at their side advising them. And none of that, well, I shouldn't say none of it, most of that did not allow for remote proceedings. We have a system in the United States where in the federal courts, we write our own rules. We can change our own procedures. We don't have to rely on the other branches of government to do that, but it is a very slow system that requires a series of public hearings and public notices and public comment periods, and we could not change the rules quickly to allow for criminal proceedings to occur on the schedule they had to occur. And so we turned to the United States Congress, and we can talk about this later if it's of interest, but working with Congress, within about 2 weeks, we got a statute passed that gave federal judges in criminal cases the ability to hold hearings remotely with the consent of the defendant and his or her counsel. And so we quickly pivoted to holding remote hearings as well in criminal cases, and fortunately we're able to keep the criminal cases moving within the time allowed in the Speedy Trial Act. One other comment I will make is we had the same concerns that we've heard from Slovakia and Croatia of public access to the justice system and public perception. And although it was challenging at the beginning, I would say that I think it has been a net positive. It's been a beneficial experiment in remote courts that has increased public access in our country and that I hope we learn from. We found that in lots of cases in state and federal court, the appearance rates for defendants, especially unrepresented people, actually increased when we went to remote proceedings. People we found were more able to participate in their court hearings, especially in smaller dollar matters like eviction cases or landlord-tenant issues or small debt collection matters, because people could get on a computer or go to a friend's computer and participate in the court proceeding, and they didn't have to travel a distance to the court. They didn't have to take a day off work. And so we actually had appearance rates go up in many of the kinds of cases where we historically have had difficulty providing the level of access to justice. It was not perfect, but we are encouraged that we found ways to actually increase access to justice within the country. The last comment I will make is there's a judge in Arizona who calls the pandemic the Great Digital Accelerator. And I think that's a good description. For us in the federal courts, it was a great digital accelerator. We took what I think would have been a decade's worth of learning on how to do things remotely and digitally, and we compressed it into a couple of years. And although there were challenges and difficulties along the way, I'm hoping we can use that to make our courts more accessible, to decrease the cost of being a participant in our court system, to make it more transparent to the public and have it be a net benefit over time.
I have to say, there's so much to celebrate in that. There's so many good aspects of that, not only in, again, the acceleration to the digital and increasing access to the courts, making them more accessible. But again, as I will keep highlighting the areas of commonality across all of the countries that we've heard so far, are first the challenges of what was, the challenges of the rules that we had before pandemic, and then the adaptation of those rules to the challenges of pandemic. But now, as we're increasingly hearing, the innovation that it spurred, the innovation that it inspired. And now, staying in the United States, although I am horrified to learn that it's almost 1,000 miles further from Arizona to New York than it is between Bratislava and London, just showing the sheer size and scale of the US. We are going to Justice Matthew Cooper, He's a former judge of the Supreme Court of New York in the USA. So, Judge Cooper, how are things with you?
Thank you, Professor Grogan, and good morning, everybody. Fortunately, I didn't have to get up as early as Judge Campbell because, and you might hear my voice is a little strained. After 3 years of pandemic, going on 4, I was pretty convinced that I had super immunity. Nope, I tested positive for the first time this morning and have some mild symptoms. So, you know, I had a certain degree of hubris that I was somehow being fully vaccinated, I would be fine, but apparently that's not the case. So, but I want to, it's amazing when I think back what happened March 14th, 2020. I was actually in India, at OP Jindal Law School. My wife and I were on a trip we were doing, and we left on March 14th to come back to the US. If we hadn't left that day, I'd probably still be living in India at that point because it was, as we know, or at least for a long time, the shutdown took place. And then we came back. Here I was. A few days later, I was back in court. And just to clear up one odd, I'm sure it's a very common misconception because it makes no sense. And maybe Judge Campbell knows this, but in New York State, the state that I live in and where I was a judge, the Supreme Court is not the highest court. It's not an appeals court. It's the highest trial court in New York. The highest state court is the Court of Appeals. We just like to do things differently here. And what do I do? What did I do when I was a judge? Something you might not think of a Supreme Court judge doing, but that is how our law in New York is structured. I handled divorce cases. So this is divorce cases, which often had a family court component, custody, parental access. So the pandemic did a number of things. First of all, it played havoc with custody issues and access. And that was the major problem to begin with. How do we get parents to see children when it was when one parent would say it was unsafe outside of New York City because the perception was you'd be safer in the countryside. So we had a whole slew of these issues. Later on, those issues became one. I had a number of cases about vaccination. Could the child be, would one parent override the veto of the other parent to have the child vaccinated? Or if a parent refused to be vaccinated and refused to follow COVID procedures, could you suspend access? So COVID itself gave rise to a whole panoply of issues. But then along with that, we have this amazing experience. And I think I love what Judge Campbell just said about the digital accelerator. That, I mean, the idea, I never did one of these calls. I never did a Zoom or a Teams. The fact that it's now somewhat second nature is amazing how fast it went at warp speed. There was a television, a cartoon that was very popular in the US when I was a kid. Maybe Judge Campbell remembers it well, called The Jetsons. And The Jetsons took place in the future. And one of the things that seemed almost impossible is that when George Jetson would speak to his wife, he did it on a screen, so he could actually see her. That seemed to be something that was fantasy, that was fun. It was never going to happen. And look what happened. So there's been, I'm not going to again not speak too long. My voice isn't going to hold out. But I just want to make a few points. One, and I didn't want to be the naysayer here. I wanted to put because there is another element to all this. And although virtual has been great in so many ways, and we were able to, the court system was able to keep, all court systems basically are able to keep functioning. What happens now? Are we better off continuing with virtual? And I would say not all cases, not all situations. Number one, I found it's much harder to resolve cases if you don't have people in the room. And it's much harder to do it virtually. Maybe some people are more adept, but I haven't been. The second thing is that I've done a number of trials virtually, and it really is still harder to get, especially let's say you're doing a custody case And in New York, the law is best interests of the child. And one of the things you have to do is ascertain the sincerity and the parenting skills and the general personality of a parent. That, I submit, is more difficult when it's done one-dimensionally, when they're not actually there and you can't see the body language. And then the third thing that I think is an issue we'll have to deal with as we continue in this taking the benefits of virtual, do we lose something in terms of the decorum? Do we lose something that people take the process less seriously because they can do it from there? I mean, I had cases where people would be either in their cars. One case where someone was in his bed wearing his pajamas. And how do we maintain the same rules? The courthouse where I worked was 60 Center Street. I know if any of you have seen another television reference, Law and Order. It's where Law and Order was filmed. And it has these impressive steps and you walk up and there's a portico and the courtroom is definitely majestic. And the question is, do you lose something when people don't come to our temples of justice, when they're just doing cases, they're logging in from wherever they can be, from their home, from their office, from their car, from their bed? Do we lose something there? So those, I think, the issues that are going to go forward as we determine what role. I mean, hopefully one of these days we'll be finished with the pandemic. I thought we were, but I'm living proof that we're not. But are we ever going to be, when we continue with a virtual world with all its benefits, are there certain things that would dictate in favor of returning at least some proceedings to the actual courtroom? Okay, so thank you. This is a great pleasure to be here.
Many thousand thanks. Do you know, I thought it was only my students who were appearing to my lectures still dressed in pajamas and sitting in bed. So I'm somewhat almost relieved to hear that also happened in the courts. My students will be delighted to hear that. But now we move again across the world to the largest democracy in India, and we turn to Advocate Purva Jha, an associate in the Dispute Resolution Practice Group at the Khaitan and Company. Again, for her experiences of what pandemic was like in action. Apurva.
First of all, I would like to pay my deepest, warmest regards to all the esteemed panelists. So my job during the pandemic, I'm a graduate during the pandemic. I graduated in 2020. So apart from the student experience, I also got the court experience when I joined the Chief Justice of the Delhi High Court as his legal researcher. And throughout the pandemic, we had a lot of issues in India. I mean, the scale, the magnanimity of India is completely, it could become absolutely mind-boggling to even just manage a small district, let alone the entire country. So the high courts and the Supreme Court in India, the high courts are basically the top court of that particular state. They make the law of the land for that state. So during the pandemic, there are also state and center issues which come up. So the Indian Constitution divides certain subjects for the union to decide and certain subjects for the states to decide. Health as a subject is under the domain of the state. So whether it was making law, whether it was making policy or the implementation of that would be the responsibility of each and every state. But then, of course, that would not allow us to manage such a huge country, a population of 1.3 billion. So the Disaster Management Act, which was from the British era, so it was enacted during the famines pre-independence. And this act was brought in again so that the center could have the power to regulate certain aspects of disaster management within each and every state. So during so we had policy changes which kept on coming, but most importantly, the significant challenges were allocation of resources, because during the second wave of the pandemic in India, we saw misery and we saw death across each house, at least in the state of Delhi. And the basic reason for that was there was a shortage of oxygen. So the courts where we were there, and we had just turned virtual, where in a system where nobody knew how to operate computers. Many people did not know how to operate computers. In fact, including the honorable judges, because they had always worked with books and with papers and with physical appreciation of evidence. Here, you did not have time to get anything physical, but you did not even have the time to comprehend the situation, because 1 hour of delay could actually lead to death of 1,000 people. So the biggest challenge that came up was that how would a court actually be in court and also ensure that something that the order which was passed was actually being enforced? There was no way for courts to actually see that. So and apart from that, the volume of petitions that came up, like Justice David Campbell just mentioned, that it was more and more people were approaching courts because it was now virtual. So even if you could not get a bed in one of the hospitals, you approached the court, invoking your fundamental right to access to healthcare. So how could you manage when you did not have 100 beds and you had 1,000 people asking for those beds? So it is a remarkable success that what the Indian bureaucracy and the Indian judiciary has actually delivered. And at no point one can say that the courts and the bureaucracy have functioned separately. This was one of those few times when actually they came up together and they functioned together. We saw, very deep consultations between cabinet secretaries and the judges as to how and what resources are actually available. It shouldn't happen that we grant a relief to a person and then they can't really, there is no resources for them to be allocated. So there were a lot of consultations. In fact, there were this was a 45-day marathon. That's what we called it. And the court would start at 10 a.m. and the honorable justices would hear the cases and be online till around 10 p.m. at night. And every 15 minutes, there would be some other case that would be coming up. And within 3 minutes, they would have to give a decision. Okay, you have to allocate oxygen to this state. You have to allocate oxygen to this hospital. And the one thing that I would definitely want to mention is that there were a lot of policies which never existed in India. India today does not have a national emergency legislation per se. There is no legislation that we had. So there was no accountability on any of the departments as to which department is actually supposed to do what. There was absolutely no allocation. So the courts had to come in and actually formulate rules at that point of time for different departments. So and this was so wide that, just giving an example, that we actually made laws that how the insurance amount would be dispersed, to how oxygen would be allocated from the center to the Delhi government. So the ambit was so large that literally everything that we can imagine came to the, it had to be rescued by the courts. And as an insider, as a staff working behind, at that point of time, our own personal families were also suffering and they were also in the pandemic. A lot of our staff were losing parents, losing family, but they were still online, logged into a computer, trying to make, smaller briefs of these petitions so that it could, we could just brief quickly and so that a solution could come fast. And I would definitely say that what Indian courts have done is remarkable, and it is made for a case study for the world to understand that how actually disasters are to be managed. So I would just like to conclude with that. Thank you so much.
Gosh, that was fantastic. And I would again just pick up on key themes there of the role of the courts stepping in where there is no law, where there is no guidance, but also the challenges of that in terms of allocation of very scarce resources. That in ordinary times we would expect this to be a political matter for politicians to be telling how resources should be allocated, where the oxygen should go, and giving guidelines. But in an emergency, what do you do? Especially, and again, we keep coming to this, the human element, that making these difficult decisions, even when your own family is so directly and individually affected. I can only echo again the challenges being universal across the world. Just to say to everyone out there listening throughout the world, we do have questions open. So if you do have any questions for our very esteemed panel, just pop them in the chat and I'll sure to pick up on them. But what I'd actually like to turn to first, before we try and identify some lessons for the future, is just think again about the key challenges. So the key challenges that each of you have found or seen through pandemic. What are the key challenges that you think that we must discuss in any context of courts and COVID? What I also suggest is we go in reverse order. So unfortunately, I'm going to put you on the spot and stay in India and say, well, what key challenges beyond those that you've identified do you think that we should really think about when we think about courts and COVID? Staying with you.
I think the major transformation that is required is the infrastructural aspect. In India, you have the high courts and then you have multiple district courts. These district courts can be in the remotest of the areas where probably there are no washrooms. How do you get Wi-Fi's there? And how do you get a virtual setup there? So right now in India, we are seeing a revolution with respect to the lower subordinate judicial infrastructure that has been created. And it is, I think, it would take time because we have a serious lack of training with respect to this. But I think in the next 10 to 15 years, we would definitely be completely virtual with respect to our justice system. And another, I think, one very important thing to look at is the appreciation of the appreciation of
You're back.
Was I gone through? Is it corrected?
Just for about 10 seconds, again, showing us the challenges of digital interaction.
Absolutely. So I think just that I said that we need to build up the infrastructure for virtual courts to exist in the first place. And secondly, especially with respect to the pandemic, we realize that we really need emergency legislations all around the world. How can any kind of emergency, not just health emergency, but any kind of emergencies, how can courts actually manage it? That needs to be put on paper, at least till the extent it can be codified. Then that would be one thing.
Many thousand thanks. Let's turn back to the States. Judge Campbell, what do you think were the key challenges that you would like to talk about?
Well, obviously we're in different countries and different situations, so I would identify some that face the federal courts. We were fortunate that our technology worked quite well. We didn't generally have connection problems. We did have to acquire 2,000 more web connection methods for the courts to work, but we were able to do that. The one place where we had the greatest connection challenges were in the prisons, where individuals were appearing in court remotely, because we couldn't transport them in small vans given the contagiousness of the pandemic, but that was something that was solved within a few months. So fortunately, the technology side of it was not a great challenge for us. I would say that, well, let me mention one other thing we did. The biggest challenge we faced at the beginning was that the courts didn't have the power to hold remote hearings in criminal cases, and we had to go to Congress, and fortunately, our national legislature reacted promptly and the president signed the legislation. But one of the things we decided at the time was that we needed to build into our existing rules of procedure the ability for courts to handle emergencies more efficiently than we did this time. And so the rulemaking part of our federal courts has set forth a set of emergency rules that will apply in the future when an emergency arises if the governing body of the federal courts declares an emergency. So we won't have to go seek legislation. We'll have the ability to do that quickly on our own. And so that challenge hopefully will be less daunting, at least in a new emergency in the future. I would say one of the greatest challenges that came to the forefront during the pandemic was what I would call the disparity in digital access. You know, the more affluent people in the United States have good internet. They have computers. They know how to use them. The less affluent in many locations had greater challenges doing that. And we learned from that. One example is in Washington, D.C., in the municipal or city courts where they were dealing with things that I mentioned before, like landlord-tenant problems or small debt collection problems. Often the individuals were unrepresented and they didn't have a computer. And so the city set up remote computer locations around the city so that if you had a case in court, you could walk 3 blocks down and go to this address, and there would be a technical person there that would sit you down at the computer and get you connected to the courtroom, and you could participate in your hearing even though you didn't have a computer back at your house or know necessarily how to use it. And that's one instance where the appearance rates, the participation rates went up significantly. Now, it didn't work that well in all places. There were some people who weren't technologically adept or didn't have the technology who weren't able to take advantage of it. So a challenge we have is to deal with this digital divide, this disparity, and try to bring greater computer access and connectivity to everybody within the country, because I think in a future emergency that will prove important. The last thing I will say is, unlike Justice Cooper, where his cases in family law and divorce cases are that's an intensely personal environment. I don't have those kinds of cases, nor do I have the kinds of cases that Advocate Jha described, where in India judges actually had to decide who gets oxygen or who gets access to health care. We were not confronted with those kinds of problems. And so I'm in a court where remote proceedings were not presenting some of the problems that they would in other locations. And I'm sensitive to that. And listening to the other speakers has increased my sensitivity to that.
Many thousand thanks. And again, as we see that even if we all have universal challenges or universal realities, we still do have divergences or diversities between resources that we have. But staying in the United States and hoping that you're not feeling too ill, but we're going over to Justice Cooper.
I'm hanging in there. So.
Hanging in there.
My wife just made me some chicken soup, which is the U.S. remedy for anything that ails you, right? So actually what I would say is, despite some certain misgivings about digital, I'm still actually amazed at how we were able to do this and how we were able to go at warp speed. I want to talk about the digital divide. I think one of the problems with this, probably not often spoken about, and this is from a personal view, older judges posed a problem. Judges like me who didn't grow up with technology. But I'm realistic to know that I'm not. I was the past generation, not the new generation. And I think as people become, I mean, every kid who grows up from the time they're 2 years old, they're in their pram with a digital device. This will be second nature. And if you think about how fast technology moved, some of my concerns will probably be addressed. Like, you don't get a sense of the people. I presume at some point we will have like holographic images of the people, and it will be far closer to virtual reality. That's scary in some ways, but also promising in others.
You reminded me that I found out that my son, who cannot speak yet, he's just over 1, was somehow able to scroll through phones, which is terrifying to me. That he can't walk, he can't speak, but he can scroll through a phone. Even when I keep it from him. Scary times. But again, sticking with this idea of challenges, what key challenges can we identify? Let's turn again to Croatia, and Judge Fatma-Tan. What do you find the challenges?
Yes. Well, there were 3 challenges. As you know, in the European Union, some countries still have a problem with backlogs. I don't know if that's the case in the United States. I know it was a problem even in UK during the pandemics. So our government didn't want us to add some more backlogs to already existing ones. So it was either to do the remote hearings or not to do anything. So it was our duty as judges to continue working, at least in cases where that was possible. Of course, we were greatly dependent on technological possibilities throughout Croatia, because not every court has the same technological capabilities, and not every court doesn't have any IT experts to introduce Teams, Zoom, or Jitsi, or any other platform. We were completely self-taught with those platforms, so we learned through practice. With remote hearings, we also taught others, but other participants, lawyers and clients and corporate lawyers, how to deal with platforms. We established an entire new system of how to give good quality informations or help in any kind of in any way for those who had to participate in remote hearings. Also, some judges were willing to participate and to have remote hearings, some didn't. That was also a little problematic. But the thing is that in Croatia we had only one article in Civil Procedure Act that said you can do it using video conferencing platforms. Nothing else. So we didn't know how to start, where to start, and everything we developed during these 2 years was actually the good practices, and we were learning on whether something was shown as good in our practice and whether something was not good. So what wasn't good, we didn't use it anymore, and we just stayed with those things that we found very useful, and just built up the system from that. So it was a very good experience for me, and I learned a lot, and I think that promoting uses of technology that enhance the justice system and enable more efficient, timely, and accessible justice for all is a key responsibility of any modern judiciary. So I didn't use a remote hearing only in the time of pandemic. I'm still using it because it is shown, especially in commercial litigation cases, that it is more suitable for everyone. So the lawyers are very happy not having to travel long distances, especially in this winter time, especially with prices of gasoline in Europe as they were. And I think we moved our courts into 21st century finally. Thank you.
I think that's a key point that we'll come back to you on, which is this is an innovation that we need to take forward, that this is something that is widening access, but as we've already heard, that we need to be aware of still the challenges to ensuring that access. But going now, and again on this idea of what are the key challenges, let's turn again to Judge Stavisky and ask, well, what do you think are our key elements that we really need to acknowledge too? Just in case there was any kind of internet issues, how about we first actually go back to the Constitutional Court of Slovakia? And Judge Bernarski, what do you think? What are the key challenges for you?
And provide less practical examples, because our Constitutional Court, because of our judicial protection, is just an examination court. So the Constitutional Court doesn't often deal with concrete cases that we would need physical hearings for and to meet court proceedings participants. We are a constitutional court, so we usually only work with the file, with the documents, so that we can examine or explore the decisions of the general courts, in whether they interfere with the basic or the fundamental rights and freedoms or not. So the experience of our colleagues from abroad, we haven't felt this that way. We have two formations in our Constitutional Court, in the plenary session with all the 13 judges, or in 4 senates with 3 judges of the Constitutional Court. And the decision-making activity happened in person as judges of the Constitutional Court. We had some exceptions in legislation so that we could come into the Constitutional Court and return back home. Of course, these were all realized with respect to the epidemiological measures. So similar problems or obstacles that our colleagues experienced, we didn't really have any of those, but from my experience or knowledge about the general courts in the Slovak Republic, Slovakia adopted the relevant legislation, especially on the level of the executive power, where it specified certain proceedings which need urgent decision-making, where courts could organize proceedings and hearings with the respect to all the pandemic measures as well. And regarding the other cases, well, they were slowed down. The proceedings were slowed down. And today the Constitutional Court has constitutional complaints where the people complain about their fundamental rights not being fulfilled in terms of the access to justice and judicial proceedings without any delays. So this, of course, for our decisions, we consider the restrictions which were there during the pandemic. So we are a bit more forthcoming to the decisions of the general courts, but only in relation to the schedule of the implementation of the epidemiological measures. This is the practical side. In my first intervention, I was a bit more general than my colleagues, so I would like to get back to the general challenges that our society is dealing with and how we saw them as judges in the decision making. I think they are especially some kind of a way to learn some lessons to help us in the future, how to perceive our environment, how to adopt future measures and steps that will be perhaps accepted in terms of the restrictive measures which can happen in the future in similar situations. So these are the lessons learned that we have to take from that. But another thing is that we have to place emphasis on education in the society. The Slovak society has a depth in this regard in terms of the education of the individual. And I think that if over the last 30 years since the Velvet Revolution in 1989, the education, if it was saw as more important, then I think the approach to the pandemic measures from the public would be better. They would understand it more, and there wouldn't be so large divisions in the society. So that's it from my side.
Again, just excellent. I would again. I realize I keep echoing everyone, but I agree so much with the panel. I think picking up on public education, on the understanding of the public is something that is very often overlooked when we talk about courts and legal system. But staying in Slovakia, I just want to know if Judge Stanisky is around, or unfortunately he might still be having some internet issues. So staying in Slovakia, do we have another Slovakian contributor? Well, on the hopes that he might contact us and say that he's been able to return to the internet, again, showing us the challenges of digital participation, we might actually stay for another question with Judge Bernowski, and instead pick up on something that we are seeing a lot in Q&A, and thank you so much to the contributors for some great questions. A lot of the questions are about the practicalities of judging through pandemic. And I'd like to pick up on two of them very briefly. So the first question asks, how has the role of law clerks and advisors changed, especially with the challenges to time and how much they can be relied on in pandemic? And the second question is talking a bit more specifically about case management and electronic filings. Is this another huge push forward through pandemic, and how have they adapted in pandemic situation? Again, representing Slovakia with our gratitude, we stay with Judge Bernowski.
Thank you very much for the question. The question of the specific realization of the decision-making activities and the relation between the advisors and the judges. Well, we of course did this in line with the pandemic measures. That means that advisors had to work from home. Judges and advisors were communicating electronically. The Constitutional Court has an electronic register of the cases, so they are all registered also in hard copies, but also electronically. And the individual advisors could work from home with the register of the Constitutional Court from home. So our communication was electronic, and I don't think this made the contact between a judge and an advisor harder. The question is whether the work from home has some impact on work discipline of judicial advisors or judges themselves, how it impacts the work engagement. Of course, working with a judicial case is different. If you have 3 small children running around at home and every one of them needs to deal with some homework from school because they had distance learning as well, e-learning basically. And in this regard, there were some limitations in terms of the work performance. This is something which is quite natural and nobody can be held to account for that, of course. But after the peak of the pandemic line passed and after we returned back to the normal working life, the question is whether the individual employees or judges themselves can feel certain stigma or certain burden in terms of the work performance. Well, I think that it is quite early to do or to draw any conclusions. I have no information about any research being done in the Slovak sociology environment. I may be wrong, but it has to be said that in terms of the work performance, working from home was an objective hurdle to the work performance being the same as not during the pandemic.
Again, showing the adaptations that are needed. I wonder, was it a similar experience for you in Czechia? No, not Czechia, Croatia. I'm in the wrong part of Europe.
Yes, that is an interesting question, because it will truly seem during this panel that Croatia somehow has foreseen the pandemics, because we had introduced in our act to be able to have remote hearings. But I must say that we also had e-communication that was used for a few years before the pandemics with attorneys and all those who wanted to use that kind of service. So we didn't have actual problems in that area. The attorneys could communicate through e-communication with courts, and that was not an issue at all during pandemics. But also we opened for those who are not participants of e-communication. We opened our mails, we opened our phones, we opened any means of communication that was available to people. So we stayed open, and I think in my case, no one couldn't say anything about me not being available at any time. We also worked in shifts for some time. So my typist was in the court in the morning, and if someone had any kind of message for me, she would contact me if something was urgent. And I must say that in Croatia we still have a paper case file, but also we have electronic case files. So we doubled work. And these days that was not a problem, because we were used to that. But now when the inflation is growing, it is normal that our clerks are asking, are you going to raise our salaries? Because with digitalization of judiciary, they get more and more work, but they don't get any financial satisfaction for that. So we didn't have any problem letting people to communicate with the courts during pandemics, and that was something that we are quite proud of. Thank you.
I think, again, picking up on the challenge of resources, and I say sitting in a state where most of the public services are now on strike or planning to strike. So it's a fun time to be here in the UK. But let's whiz over to the US. I understand Judge Cooper may not be able to stay with us too much longer, so I'll ask him first if he'd like to offer any thoughts on just practical issues or practicalities of courts in COVID.
Well, I think my first reaction to all this is how dedicated judges are, whether it's Slovakia, whether it's India, whether it's Croatia, whether it's the US. How it's amazing that when this all happened, people didn't say, you know what, I guess I don't have to go to work now. I can't do anything. You know, I'll stay at home and collect my paycheck. No, people still delivered, and everybody joined that. I know in my courthouse, it really was a collective effort. You know, it raises problems as we just heard about the work for clerks, and as you just talked about the strikes by government workers in England. But you know, and people should be compensated for what they do. But it is amazing how dedicated everybody was, and how people, you know, the expression we use in the US is roll with the punches. It sounds like everybody really did. in history where the rule of law is under attack in so many countries. And it's inspiring to see how dedicated judges are in every country to what they do, to delivering justice despite the obstacles.
I think that's a really wonderful message. It was almost a dramatic message. I wish you would repeat at the very, very end of this. But no, I turn to Judge Campbell, and again, what practical changes? Although maybe you might just echo just the incredible dedication of judges throughout the world.
I agree with everything that Justice Cooper just said. On the specific questions that were asked, like my colleague on the Constitutional Court in Slovakia, we found that working with our law clerks, who are trained lawyers who assist us in our research and writing, worked quite well remotely. I have 2 law clerks, and they continue doing their work as if they were in the office, and we communicated digitally and by phone and had meetings of our chamber staff remotely, and that seemed to go quite smoothly. One of the questions asked about case management and online filings. As I mentioned earlier, we've been on an e-filing system for more than 15 years, and that worked very well and really saved us in our ability to keep the cases moving because everybody was able to do their filing remotely. In terms of case management, my judicial assistant was working from home, but she was able to access fully our court computer system. She could do all of the same monitoring. She could do all of the same checking of deadlines and case progress and prompt me when case management needed to be done. At the beginning of cases, I held case management conferences remotely with the parties and set the same kind of schedules. Sometimes they had to be adapted a bit because things could not be done in person as much, but those schedules were set, those schedules were followed. So on those practical issues, I think technology allowed us to function quite well. I do think that on other practical issues, we proved, or we being the courts generally, I don't mean me, but proved that technology really can aid us in a lot of ways, being very sensitive to Justice Cooper's point that we don't want it to completely replace the dignity of the court system. There were lots of courts in the United States who started using text messaging applications to remind litigants of scheduled deadlines. There were courts who set up mobile queuing applications where a person who needed to schedule a hearing could do it from their cell phone and schedule a hearing and participate in the hearing by cell phone. In fact, in the state of California, when they went to that kind of an app and individuals were given the choice between participating in their court case in person or remotely, 75% of the time they chose remotely. I think that reflects the fact that our society is becoming more digital and they were comfortable doing it, and it was probably easier for them, which is one of the reasons that the participation rate increased. One other very encouraging development from my perspective was that we heard from lawyers who provide legal aid for the poor and who do pro bono work that they were able to be more effective working by technology than they were under a system where they had to travel to court hearings or travel to meetings with clients. They could get more help to more people in a day using technology than they could before using technology. And so that was a practical development that I thought was very positive as well.
Just before we turn to India, I'd like to remind everyone out there that we're going to have a participation, and we hope for participation from the wider audience. So if you'd like to ask a question, raise your virtual hand. I have no idea how to do that, but raise your virtual hand, and Max will be coming to you next. But first, over to Advocate Jha. What do you think about practicalities?
On the very specific point of filing of cases, I think in India we do not have any system of e-filing or electronic mode of giving affidavits or evidences. We had to somehow create it during the pandemic. So whether it was the Supreme Court of India or whether it was the high courts, they had to introduce the new mechanism during the pandemic. which turned out to be much better for litigants, I feel, because now there is also a lot of red tapeism that comes in when it comes to physical filing. Now that has been eliminated, at least from some courts. So that has really helped. Apart from that, what we've all talked about, the role of law clerks, I think it became much easier for law clerks to function, because in India you had a lot of issues. Our courtrooms are very small. We don't have places. They were never made with an idea that there would be a time when judges would also need assistance. So it was never made like that. So you don't have place for law clerks to sit, even in the Supreme Court of India, most of the courtrooms. So this has kind of enabled a new system. At least younger lawyers, younger minds have got that space and entry into the judicial system through, I think probably the benefit of having older judges came to us, that we could exploit our knowledge of technology there. So I think that has really helped. And I would say that even, if you leave the Delhi High Court, which is a much more advanced High Court compared to a lot of other High Courts in India, or the Supreme Court of India, even the other High Courts kind of, the involvement of law clerks has certainly increased after the pandemic, because judges have also realized that now, it can happen virtually. People can assist us. Earlier, there was no concept of assistance to a judge that existed. Probably it was just their internal staff who would be giving them files. Now there is also a research that could be put on table. So I think that is a great change for our judicial system, for sure. That is one thing. And like I said, the entire filing system, a new system has been created. Now we are trying to introduce it at the district level, which is a little tougher, of course, because the procedures are different. But in India, actually, the high courts have the power to make procedures. We don't have, like Judge Campbell was talking about, that the parliament or the legislative body has to approve it. In India, we do not have that. The chief of the high court can make a rule, and the judges can approve it, and that would become a procedure of that court. And that would be then circulated with the entire bar of that court, and then that becomes a rule. So I think that had kind of aided us, that courts realize their specific problems as per their geography, as per the population, as per the number of courts, and they could make a new rule for themselves. So I think that has really helped us here.
Thank you. Again, just picking up on the innovations that pandemic is bringing. Now, aware of the time, and also aware that I have one final question that I want to ask, and I'll abuse my power as chair of this panel. I first, again, like to ask if there's anyone in the attendees or audience that would like to raise a virtual hand and ask a question of our panel first. I'm going to just look over, see if we have any questions from the audience before I jump right in and get my own question. So I'm going to give an arbitrary 3 seconds left if anyone wants to ask a question. My very arbitrary 2 seconds left, and a final arbitrary 1 second left. And now I'm going to abuse my power as chair. So my final question to the entire panel, and it's something that I, in my own work and in the positions that I've taken on, have to grapple with, which is, well, what next? What are the essential lessons that we must learn in the event of not necessarily a future pandemic or public health crisis, but for the next emergency? So what key lessons can we draw from the COVID-19 pandemic that we must bring forward to the next emergency? Again, turning back to our wonderful host country in Slovakia, we turn to Judge Winiarski. What do you think? The key lessons?
I believe that, first of all, we can implement certain changes, certain powerful changes of the legal regulation which deals with these situations. But I don't think that in the judicial regulation as such, or the legislation poses the main problem. In the Slovak conditions, legislation basically is an expression of the values of the lawmaking power, but it's also some kind of a manual of how to behave in different conditions. For example, if we have such crises as this pandemic. But I have to repeat that in this regard, changes are technical questions. This kind of change can be performed, can be implemented, and it can be viewed as a positive change for the future. But what is a deeper society-wide problem is the perception of legislation, the relation of an individual to the institutions, and the trust has been jeopardized, especially during the pandemic, because, as I mentioned, there was no preparedness for such situations. The individuals were really surprised by the level of restrictions that were implemented. They didn't understand the restrictions. They saw some problems with them, even though they may be small, but they were very much criticized in the public and perceived very negatively. So I think the biggest challenge is that institutions have to enhance the system of their functioning, and they always have to be ready to adopt measures fast, but also explain them to the public and to justify them. There was a large disinformation campaign in the society, and this exists. This is a fact, basically. And the question whether we can compete with that, well, that's a question, but we have to at least try, we as the institutions and authorities of the public administration, by providing trustful and reliable information so that the legitimacy can be regained by those institutions and authorities, and then the cooperation of the individual and the authority can be improved and can be very good and effective in other crises in the future. Thank you.
In a way that will surprise no one, I completely agree with everything that has just been said. But we will continue to Croatia, to Judge Mactan. Just before that, I would say that there's been a really, really interesting question, and I will come back to Slovakia on this, that I think, well, I hope everyone will also have an opportunity to think about. It picks up not only on what we've just heard about disinformation, public perception, but it asks how political polarization in COVID-19, particularly around the measures that were taken, around vaccinations, around lockdown, how that impacted on judiciaries. So this extreme political polarization that we've seen throughout the world, how that impacted. But we can also, again, look to lessons. First, though, to Judge Mactan in Croatia, what lessons? What do you think?
Yes, thank you. Well, we already knew that new technologies connect people in different ways. So remote judging was just another tool given to judiciaries around the world to enhance their work during that difficult times. And I think that remote judging principles that we learned during the pandemics can also be used in any other situations that were unexpected or urgent. And remote judging is especially important for those countries that are huge. Like I've talked to African judges, and it is they made quite a step forward in their judiciaries during pandemics for functioning of the courts, especially because, as you know, in some areas, rural areas of African countries like Kenya, Tanzania, Uganda, the roads are not very good. So that was, but where there is electricity and internet, they can most certainly operate better. So remote judging was also a window of opportunities for some countries. Maybe not for so much for smaller countries, but for huge countries like India, perhaps, there would surely be a future for remote hearings. Thank you.
Many thousand thanks. Judge Campbell, what do you think?
For years in our country, we have struggled, wrestled with questions of access to justice. We have found that our civil litigation system is becoming increasingly expensive, which means fewer and fewer people can participate. We have found that that the lawyers are not able to provide services to all of the people who need it, and we've been very concerned about how to solve this problem. I think that the pandemic has been a very great help in that area. I think that we've learned that we can increase access to justice through remote hearings. We can decrease the cost of litigation by using technology. We can provide more attorney assistance to individuals through the use of technology. For me, it is the most encouraging development I have seen in my 20 years as a judge in helping to grant greater access to justice for the people who need it. A related point that gets to the question that you asked Professor Grogan a minute ago, it also, I think, increases the ability, or we've learned that we can use technology to increase the ability of the public in our countries to see what happens in the courts. In the United States, the kinds of court proceedings that you tend to be able to see on television are these dramatized, sometimes almost comical representations of what happens in court. But through technology, people on their phone can watch what's happening in an important criminal case, or if there's a case involving a family member or a public issue they care about. We have the greater ability to observe what's going on in courts, greater transparency, which I hope will help with the larger problems that you asked about in your last question of disinformation and political polarization. If our citizens can see government in the courts working in an objective, impartial, fair manner, where the courts really are trying to find the right answers, not driven by ideology, I think that could be a powerful antidote to some of the political polarization and disinformation that we are all wrestling with nowadays.
Many thousand thanks. Judge Cooper, are you still surviving?
I'm still hanging in there, but I agree wholeheartedly with what Judge Campbell said. It's sort of counterintuitive, but one would have originally thought the pandemic was going to turn back the rule of law, was going to turn back access to the court systems. And in fact, it hasn't, and there's a potential for doing so much more. So even though I do see some pitfalls, overall, it is a huge positive thing. Just one other thing, I know I was called upon to make it, we talk about polarization, I was called upon to make some decisions concerning COVID as precautions. And in one case, I made a ruling, which then resulted in going viral and me basically having to get court protection because thousands of people got on the internet to start talking about these horrible things I was doing to a particular litigant based on COVID. So we do, there's always that part of the internet too, the misinformation part. And if we could just get that somehow in check, there's a great future here.
For a moment, I thought you were going to say that you were part of that viral video of that poor advocate that was a cat. I think that he was a poor guy was arguing as a cat. But no, again, echoing a very real point, which is when you're at the forefront of very difficult decisions, especially in a very difficult political environment, that not only do judges have to sacrifice so much and be so committed to the rule of law and justice, but very often at personal cost. But again, I'm glad that you didn't appear on the internet as a cat. Turning to India, Advocate Jha, what do you think?
I think that in India, the major issue during the pandemic was the political tussle that was between the states. But there are a few things about Indians. First, we perform best under pressure. Second, we forget very easily. And third, we always listen to our courts. So if the courts say that this is supposed to happen, nobody questions that. So if you look at the early days of the pandemic, there was the Supreme Court of India ordered that in case of any obstruction for any government official or for any doctor or for any person who was working or providing their services during the pandemic, if there was any obstruction, strict action should be taken. And resultantly, the Parliament amended the Disaster Management Act to ensure that there were penal provisions which were included to, amounting to imprisonment of 3 months to 6 months, and including a fine of about 1 lakh to 5 lakh Indian rupees in case you were found obstructing any kind of activities that were during the pandemic. So I think that was one thing. But second thing, like I said, that when the courts say something, we all listen. So I think that was one of the major roles that the Supreme Court played out. So during the pandemic, there were SOPs which were given by the Indian Supreme Court to many of the ministries. And I think those SOPs are going to stay with us for a long time, which we can innovate in future and use for different emergency situations. And one last thing I think would be that we all understood the situation that we were in. It wasn't that there were a certain group of people who were not understanding that. That was something that unity in diversity. That's how you know India. So I think that was at the best, and it was showcased at its best during the pandemic, because whatever came from the courts was definitely followed. And now the biggest challenge that we have is that we forget very easily. So we should not forget, and we should not forget these practices, because a lot of times I think it tempts even judges to, now now they can come physically. Why do we have to log into our computers now? So start calling them physically. So that shouldn't happen, and we shouldn't do away with the virtual, the progress that we have achieved over the past 2 years. We shouldn't just do away with it because, we are just now comfortable with it. So I think that would be a major challenge, and we are all hopeful and, in fact, I would say extremely hopeful and determined to make our district courts virtual, and somehow making sure that Wi-Fi and internet access is available to each and every person, and the access to justice increases simultaneously.
Again, utterly and completely echo and agree. As I'm now stealing time from your lunches, your breakfasts, or your dinner, can we turn for a final, very, very short word of a final thought to Judge Savitsky? Final words, final thoughts on any of the themes that you've had so far.
I liked during pandemic era more symbolic side of the law. I would prefer more direct access of citizens when challenging the norms at the constitutional court, and quick response of constitutional court to those challenges. So I think that pandemic was success story from executive in Slovakia from point of view, and from practical point of view, even judiciary did well, but not from the symbolic point of view, to more show sense of protection towards citizens. So I'm not lacking like practical stuff, but more symbolic stuff to develop more feeling of citizen that if there would have been really a harsh interference to human rights, there is somebody who can hear you and very quick react to those norms which contained pandemic measures. So this is my and to develop some very technical stuff, but very important stuff, how to communicate the decisions of executive power to our citizens and stuff like that. So this is my point. Thank you.
And on that note, again, the key points that are just so shared throughout the world, it is my great disappointment to have to end this excellent panel. Can I first thank our wonderful speakers joining us throughout the world to reflect on courts and pandemic. Can I also thank our fabulous organizers, both in Slovakia and in India. Thank you so much to Max. Also, as a personal note, thank you to the translators. Slovakian is a beautiful language, and you have translated so well. And finally, thank you so much to all you who have joined us and listened in. I hope I haven't stolen too much from your breakfast, lunch, and dinner. I know I'm going straight to coffee after this, but I'll pass back to Max with my thanks again.
Thank you so much, Joel. It's been a great privilege to have you moderate this session, and I just want to very quickly thank all of these esteemed speakers for what has been really a story of hope, I think also for Slovakia, which usually talks about judiciaries in a negative manner. And I think there is a lot that we can work with within the Talking Courts project from your interventions, from your contributions. So thank you so much again, and apologies for all the technical difficulties, and we definitely hope to improve these so to enable more of these conversations in the years to come. Thank you so much. Have a great day, morning, evening, night, and hope to see you in future projects. Thanks.
Bye.